The $2 million trap, how Medicaid steals your home, and how to stop it. You paid off the house, kept the taxes current, and planned to leave it to your kids. Then a letter shows up after a parent dies. The state wants the house to repay Medicaid. That shock hits thousands of families every year. Most never saw it coming. In the next hour, I'll show you exactly how the Medicaid lien trap works, why common advice fails, and the legal tools that actually protect a home. You'll leave with a short, concrete checklist you can do this week to keep the house out of reach, legally and on time. What Medicaid Estate Recovery really is. Basics first. Let's clear the fog. Medicaid Estate Recovery isn't a random grab. It's a federally mandated process. Under federal rules implemented in 42 CFR 433 after OBRA 93, states must seek recovery of certain Medicaid costs paid for people age 55 and older who used long-term services and supports, think nursing facility care, home and community-based services, and related hospital and prescription drugs. States have to do this. How they do it varies, but the mandate is real. Now, the first big distinction: liens versus estate recovery. A Medicaid lien is a claim placed on property during life, typically in rare scenarios when someone is determined permanently institutionalized and no protected relatives occupy the home. Estate recovery is different. The state files a claim after death, targeting assets in the probate estate. Most families feel the hit at probate, not during life. That's the core risk. Here's why this surprises people. To qualify for Medicaid, your countable assets usually must sit under roughly $2,000 for a single person, but the primary residence is often exempt while you're alive. That exemption helps you qualify. But after death, federal law requires states to try to recoup what Medicaid spent from assets that passed through the estate. So the home, which was exempt for eligibility, can become the main target for recovery later. That's the paradox. What costs are they after? The mandatory category is long-term services and supports at 55 plus related hospital and prescription drug costs tied to that care. States can optionally expand beyond that, and many do. There's wide variation in scope, thresholds, and process. Some states set cost-effectiveness floors. Below a certain estate value, it's not worth pursuing. Others cast a wider net. But the through line is the same. If it's in the probate estate, it's at risk. There are protections. Recovery can't happen if there's a surviving spouse, a child under 21, or a child who is blind or permanently disabled. That's federal. States also must offer an undue hardship process, but the criteria are state-specific. In Texas, for example, heirs generally have 60 days after notice to apply for a hardship waiver. Common grounds include that recovery would push an heir below poverty, the property is a primary income source, or the homestead is modest in value relative to family income per MERP guidance. This is real relief for some families, but not a strategy to bank on. It's a last resort safety valve. Texas gives us a useful case study because it's probate only. That means the state only recovers from assets that pass through probate. If an asset bypasses probate, say through an enhanced life estate deed, often called a ladybird deed, or a properly structured beneficiary designation, it's generally outside the recovery reach. This is the key legal insight. MERP chases probate assets. Keep the home out of probate, and you've changed the game. Let me pause on notification. States must inform applicants about potential estate recovery at application and notify personal representatives or heirs after death when they intend to recover. In practice, families often miss or forget the early notice because they're focused on getting care. The wake-up call is the claim letter. That's why planning before crisis matters. Now, the Lookback rule. Medicaid scrutinizes transfers for 5 years for gifts that could disqualify you. Transfers to an irrevocable Medicaid Asset Protection Trust trigger that lookback. If you're planning well in advance, a MAPT can protect more than just the home. investments, savings, sometimes life insurance cash value, once you're outside the look-back window. But it trades control for protection and requires time. Contrast that with a Lady Bird deed in states that allow it, like Texas. An enhanced life estate deed lets you keep full control. Live there, sell it, refinance, change beneficiaries. Because the transfer doesn't complete until death, it doesn't trigger the look-back. And because the property passes outside probate, it typically avoids estate recovery in probate-only states. The catch: it only covers real estate, and not every state recognizes it. We also need to separate estate recovery from general liens. Families here lien and imagine an immediate lock on the home. In most cases, tied to long-term care at 55 plus, the state waits until death and then presents a claim in probate. That gives you planning windows: before Medicaid, during Medicaid, and after death, but before probate closes. Strategy lives in those windows. Finally, there's negotiation. States usually allow reasonable deductions from the claim, necessary home maintenance to preserve value, funeral expenses, and sometimes documented care that delayed institutionalization. Keep receipts. Organized records can reduce the net claim meaningfully. If you remember nothing else, Medicaid Estate Recovery is mandatory at the federal level for long-term care at 55 plus. States mainly recover from assets in probate, and your best defense is lawful probate avoidance for the home plus timely state-specific planning. Next, we'll map the trap in detail and show where most people get caught. The eligibility versus recovery mismatch, why people get trapped. Here's the mismatch that catches good families. The rules that help you qualify for Medicaid are not the rules that protect your home after you die. During eligibility, the home is usually exempt if you or your spouse live there. That's why so many people breathe a sigh of relief. But recovery looks at the estate after death and asks a different question. What assets flow through probate that we can claim against? Same house, two different rule books. Most people only learn the eligibility rules. They learn the asset limit, roughly $2,000 for a single person. They learn the home doesn't count for eligibility while occupied by the applicant or a spouse. So they assume the home is safe. It is safe for eligibility. It's not safe for recovery. That's the trapdoor. Eligibility determines if care gets paid now. Recovery determines who foots the bill later. Now here's where timing makes it worse. Families focus on getting mom approved for care. Understandably, there's paperwork, placement, doctors, and stress. The planning that protects the house has to happen before a claim hits probate, and sometimes before Medicaid starts. If you wait until after approval to even think about it, you've already lost key options. With a MAPT, you need to be outside the 5-year look-back to avoid a penalty period. With a Lady Bird deed, you need to get the deed right before death to make sure the house bypasses probate. Crisis mode pushes planning off the table. Another mismatch: who benefits versus who pays. Eligibility protects the applicant's housing stability during life. Recovery targets heirs after death. So, the person benefiting from the exemption is not the person who gets the bill. The program covered care for the elder. Later, the estate system seeks reimbursement. If no planning moved the home out of probate, the state has a clear path. And it's not just the home. Some states widen the scope to include other services tied to long-term care. If the home is the largest asset, it becomes the practical target. But if small accounts or vehicles pass through probate, those get swept too. The common advice to just stay under the asset limit misses the downstream effect. You can be fully eligible and still leave an estate that's recoverable. Let me show you a quick example. A widow in Texas keeps her homestead while on Medicaid. Her kids pay taxes and maintain the property. She passes. Because Texas is probate only for recovery, the key question is, does the home hit probate? If the deed is standard and there's no beneficiary designation or ladybird deed, it likely does. The state sends a notice of intent to recover. The kids scramble, then learn there are hardship rules with a 60-day clock and strict criteria. They don't qualify. The house is either sold to satisfy the claim or the state gets paid when it's sold later. If, instead, the mom signed a ladybird deed, the home would have passed outside probate and likely avoided recovery. Same family, same house, different outcome because of the probate path. There's also confusion around the spouse and disabled child protections. People hear no recovery if there's a surviving spouse and think it's permanent. In many states, it's a delay, not a cancellation. When the spouse dies, the claim can be pursued against the estate at that time, subject to state procedures. That timing leads to costly surprises. What about liens during life? For long-term care cases at 55 and older, most families won't see a pre-death lien on the homestead. They'll see a post-death claim. That means they have windows to act, but windows close. Once death occurs and the estate opens, options shrink. The mismatch is really a sequence problem. Eligibility first, recovery later, planning somewhere in between. If you don't bridge those phases, the default outcome is recovery. So here's the better frame. Treat eligibility as crisis management and recovery as estate planning. Do both. While you're applying or soon after, ask one question: how will the home avoid probate? If the answer is unclear, fix it. Use state-approved tools. Ladybird deed in states that allow it, transfer on death deed where it's recognized, or a trust if you have time and broader assets. Keep records so you can reduce any claim. The reason this works is simple. You're aligning the eligibility rulebook with the recovery rulebook. When those match, the trap has nothing to spring on. Liens versus estate recovery claims. Know the difference. Now let's separate two terms everyone mixes up: liens and estate recovery claims. They sound the same. They aren't. And if you react to the wrong one, you'll waste time and miss the window that matters. A Medicaid lien is a legal hold placed on property while the person is alive, usually when the state determines someone is permanently institutionalized with no reasonable expectation of returning home. That's the classic pre-death lien scenario. It's allowed under federal law, but there are big protections. No lien if a spouse, a minor child, or a blind or disabled child lives in the home. States use this tool carefully because it can destabilize housing during life. In many long-term care cases for people 55 and older, you won't see a pre-death lien slapped on the homestead. So when families say, "We never saw a lien," they're often right because the state was waiting. Estate recovery is different. It's a claim filed after death, and it targets assets that pass through the probate estate. Think of it like any creditor claim in probate, except the creditor is the state seeking to recoup long-term care costs. The legal authority comes from federal rules under 42 CFR 433 following OBRA 93. States must recover for nursing facility services, home and community-based services, and related hospital and prescription drugs for people 55 and older. Some states choose to recover even more, others limit it to the minimum. But almost everywhere, the mechanics are the same. The claim arrives during probate, not during life. Why this matters? Your defense toolkit changes depending on which one you're facing. Pre-death lien, you're in eligibility and placement mode, and you're weighing protections and exceptions tied to occupancy and institutional status. Post-death claim, you're in probate and title mode, and the key question is whether the asset even hits probate in the first place. If it doesn't, recovery often can't reach it, especially in probate-only states like Texas. Let me give you a clean model. Imagine two tracks. Track A is liens, used before death, tied to institutionalization, with strong federal protections for certain family members living in the home. Track B is estate recovery, used after death, tied to probate, with mandatory federal exemptions for surviving spouses and qualifying children, plus state hardship processes. Most families are actually on Track B. They never see a lien, they see a probate claim. Here's the shortcut nobody teaches. You don't fight estate recovery claims by arguing about eligibility rules. You route around probate. That's why tools like enhanced life estate deeds, Lady Bird deeds were allowed, or transfer on death deeds are so powerful. They move the home outside the probate pipeline. In Texas, that single move often puts the property beyond the reach of MERP because Texas focuses recovery on probate assets. With a Lady Bird deed, the transfer completes at death. It typically avoids the 5-year lookback, and the beneficiary takes title without probate. The claim doesn't have a door to walk through. Now, a few gotchas. First, a traditional life estate deed isn't the same as a Lady Bird deed. The traditional version usually gives up control and can trigger penalties during the lookback. The enhanced life estate, Lady Bird, keeps control, and in states that recognize it, typically doesn't trigger the lookback because there's no completed gift until death. Second, selling a home that's under a Lady Bird deed while you're alive converts the protection into cash, and cash is countable for eligibility. So the deed protects title at death, not sale proceeds during life. What about negotiation? That applies to estate recovery claims, not liens. Liens are about securing an interest, claims are about settling amounts. With claims, you can often deduct necessary home maintenance, preserving value, funeral costs, and documented care that delayed institutionalization. Keep records. This won't eliminate a claim, but it can shrink it. If you remember nothing else in this section, a lien is a pre-death hold. A recovery claim is a post-death bill in probate. Most families face the bill, not the hold. Plan for probate, not for liens, and you'll put the house where the claim can't reach. Mandatory exemptions and deferrals keep the home safe, for now. Let's talk about the protections that pause recovery. Keyword, pause. Federal law blocks recovery while certain people are still in the picture. If there's a surviving spouse, the state can't recover yet. If there's a child under 21 or a child of any age who is blind or permanently disabled, recovery is off limits while that status exists. These are mandatory protections in federal rules. Here's the part most people miss. These are not permanent shields for the property. They're deferrals. The moment the spouse passes or the minor child turns 21 or the household composition changes, the state can come back and seek recovery from the estate at that time, subject to state procedures. Think of it like a not now, not a never. If you rely on the exemption and do nothing else, you're setting up your heirs for a delayed hit. Now, how do states apply this in practice? Using Texas as a model helps. Texas does not pursue recovery while a spouse is alive. That's a true deferral. But Texas is also probate-only, which means you've been handed a planning window. During the deferral, you can move the home's legal path so it won't touch probate when the spouse later dies. A Lady Bird deed in Texas is the classic move. The spouse keeps full control for life, and at their death, the property passes directly to named beneficiaries, typically avoiding probate and therefore recovery. If you wait until the second death, and the deed still sends the property through probate, MERP has a clear lane. What about situations with a disabled child? The same logic applies. While that child is alive and qualifies, recovery is blocked. But you still plan. Align title now so that when the protected period ends, the property doesn't fall into probate. If you're in a state that recognizes transfer on death deeds, that can work too. If you need broader protection for multiple assets, and you have time, a Medicaid Asset Protection Trust, funded well before Medicaid, can keep the home and other assets outside the estate that recovery targets. The 5-year lookback applies to MAPTs. Let's bring in undue hardship. because it's often confused with these exemptions. Hardship is not automatic. It's an application with a deadline, documentation, and state-specific criteria. Texas gives heirs roughly 60 days from the notice of intent to recover to file. Common grounds include that recovery would push the heir below poverty guidelines, the property is a primary income source, or the homestead is modest in value relative to family income. Hardship waivers can work, but don't plan on them as your main strategy. They're safety valves, not foundations. You also have small estate thresholds and cost-effectiveness rules. States are supposed to avoid spending more to recover than they'll collect. Texas lists specific situations where recovery isn't pursued. The estate value is very small, Medicaid paid amounts are minimal, or selling the property would cost more than it's worth. These help on the margins, but won't save a typical homestead with meaningful equity. If a house has value and it hits probate, expect a claim. Here's a clean way to think about your options during a deferral. You have time, but you don't have certainty. Use the time to remove the home from the probate pipeline. In Texas and other states that allow enhanced life estate deeds, a Lady Bird deed is fast, flexible, and doesn't trigger the Medicaid lookback because the transfer isn't completed until death. That's why it works even for last-minute planning, as long as the owner still has legal capacity. If your state doesn't allow Lady Bird deeds, look at transfer on death deeds for real estate, payable on death designations for accounts, and beneficiary designations for other assets. The objective is the same: bypass probate. One more nuance. Families sometimes think we're safe because the spouse lives in the house. That's true today, but the spouse may later downsize or move to care. If the home is sold during life and the proceeds sit in the spouse's name, that cash is countable for eligibility. The protection attached to the house does not attach to the cash. So if a sale is likely, talk to an elder law attorney about timing and alternatives. With a MAPT already in place and outside the lookback, sale proceeds inside the trust stay protected. Without that, a sale can open up new problems. Let me give you a quick checklist you can act on during a deferral. Confirm which exemption you actually have: spouse, minor child, or disabled child. And document it. Review the deed and beneficiary designations now. Don't assume they're set. If you're in a probate-only state, prioritize tools that keep the home out of probate. If you might need hardship later, start a paper trail: income, expenses, how the property supports the family, and any factors that fit your state's criteria. And put reminders on the calendar. Hardship windows are short and unforgiving. If you remember nothing else here, exemptions by time, not immunity. Use that time to change the legal path of the home so it never reaches probate. That's how you turn a temporary shield into a lasting result. The 5-year lookback and transfer penalties, timing is everything. Before we get fancy with deeds and trusts, we need to respect the 5-year lookback. This is the window Medicaid uses to examine transfers you made before applying for long-term care benefits. If you gave assets away for less than fair market value during that period, Medicaid treats it as an improper transfer and can impose a penalty period, months where you're ineligible even though you meet all other criteria. Why this matters? A penalty period doesn't start when you make the gift. It starts when you're otherwise eligible and need care. That's the painful part. Families discover the penalty exactly when the nursing home wants payment, and private pay rates are crushing. The reason this exists is simple. Medicaid wants to prevent last-minute divestment and prioritize funds for those who genuinely need help. What counts as a transfer? Gifts of cash to kids. Adding a child to a deed in a way that gives them present ownership. Selling an asset for $1. Funding an irrevocable trust like a Medicaid Asset Protection Trust inside the lookback. These are below-market transfers. Medicaid calculates a dollar amount of the transfer and divides it by your state's average monthly nursing home cost to get the penalty months. It's math, not a slap on the wrist. Now, not everything triggers a penalty. Paying fair market value for goods or services is fine. Document it. Home improvements with invoices, legitimate caregiver agreements with time logs and payments, and necessary home maintenance can be legitimate. The thing most people miss is the paper trail. If you can't prove fair value, Medicaid can presume a gift. Keep receipts, contracts, and bank records. Let's connect this to the tools we've discussed. A Medicaid Asset Protection Trust is powerful, but funding it starts the look-back clock. If you're 5+ years from needing care, moving assets into a MAPT starts the waiting period, and once cleared, those assets are typically protected from both eligibility and estate recovery. If you're inside 5 years, funding a MAPT can create a penalty you can't afford. That's why MAPTs are for advanced planners, not crisis cases. Contrast that with a Lady Bird deed in states that recognize it, like Texas. The enhanced life estate deed doesn't complete the transfer until death, so it generally doesn't trigger the look-back. That's why it's so useful for late-stage planning if the owner still has capacity. But remember the nuance we covered. If you sell the house during life, the proceeds become countable. The deed protects the title at death, not cash created while alive. Transfer on death deeds and beneficiary designations on accounts can avoid probate for recovery purposes, but changing an account title or adding a joint owner can trigger look-back issues if it creates a present gift. This is where elder law attorneys earn their keep. Small wording differences change outcomes. A TOD beneficiary designation doesn't give present ownership, so no gift. A joint owner with rights today may be a gift. Details matter. There are also permissible transfers that won't trigger penalties. Federal law allows certain transfers of the home to a spouse, a child under 21, or a child who is blind or permanently disabled. Some states recognize the caretaker child exception. If an adult child lived in the home and provided care for at least 2 years that kept the parent out of a facility, a transfer to that child may be penalty-free. The documentation bar is high. Physician statements, care logs, and clear evidence that the care delayed institutionalization. Build the file. If you're already inside the look-back and need care, now you still have options. One strategy is partial cures, returning transferred assets to undo the penalty. Another is paying for care during the penalty using available resources while aligning assets for recovery protection. In probate-only states, that can mean executing a Lady Bird deed to control the estate path while you navigate eligibility. You're managing 2 timelines at once, the penalty clock and the estate recovery path. Here's a quick, workable plan by timeline. If you're more than 5 years out and healthy enough, consider a MAPT for non-retirement assets and possibly your home with the intent to ride out the look-back. If you're within 5 years and capacity is intact, prioritize deeds and beneficiary designations that don't complete gifts now. Lady Bird deed for the home where available, TOD/POD for accounts. If crisis has already hit, avoid new gifts, document fair value transactions, explore caretaker child or other exceptions, and consult counsel to cure or mitigate penalties while still routing assets away from probate. The reason this works is you're separating 2 questions. Eligibility asks, did you make disqualifying transfers in the last 5 years? Recovery asks, will assets pass through probate after death? You can respect, both by timing MAPs early, using non-gift probate avoidance tools late, and keeping meticulous documentation. Timing isn't everything, it's the only thing. House protection tools, pros, cons, and state landmines. Let's get practical. There are 4 main tools people use to keep a home out of Medicaid's recovery path: Lady Bird deeds, transfer on death deeds, Medicaid Asset Protection Trusts, and traditional life estate deeds. They're not interchangeable. Each has a sweet spot, drawbacks, and state-specific traps. Start with the Lady Bird deed, also called an enhanced life estate deed. Why pros love it in states that recognize it, like Texas and Florida? You keep full control during life. You can sell, refinance, change beneficiaries without asking anyone's permission. The transfer doesn't complete until you die, so it generally doesn't trigger the 5-year Medicaid lookback. At death, the property passes directly to your named beneficiaries, bypassing probate, which in probate-only recovery states usually keeps MERP from touching it. It's low cost and fast to implement if you still have capacity. Downsides: it protects real estate only. If you sell while alive, the cash proceeds are countable for eligibility, and it's not available everywhere. So using the term ladybird in a non-recognizing state can cause drafting errors that don't do what you think. Transfer on death deeds, or TODs, are another probate avoidance tool for real estate. They're recognized in many states under beneficiary deed statutes. The big advantage: they don't create a present gift. You retain full ownership during life. And on death, the property passes to the named beneficiaries outside probate, like a ladybird deed that can block recovery in probate-only states. They're simple, revocable, and cheap. The landmines: TODs vary a lot by state. Some require strict recording before death. Some void the transfer if a beneficiary predeceases you unless you add alternate beneficiaries. Some states don't have TODs at all. Another catch is beneficiary coordination. If you have multiple children and one can't or won't cooperate, title can get messy. And unlike a trust, TODs don't manage what happens if beneficiaries are minors, disabled, or fighting. Now, the heavyweight, the Medicaid Asset Protection Trust, or MAPT. This is an irrevocable trust you set up and fund while you're healthy enough, ideally more than 5 years before you'll apply for Medicaid. The big benefits: comprehensive protection beyond the house, investments, savings, even life insurance cash value in some designs, plus the ability to sell the home and keep proceeds protected inside the trust once you're past the lookback. Trust assets avoid probate, which blocks recovery, and they're outside your countable assets for eligibility after the lookback. You can usually keep the right to live in the home and receive income, and many MAPs are structured as grantor trusts for favorable tax treatment. The trade-offs are real. It's irrevocable. You can't take principal back. You'll need a trustee you trust, and setup is more expensive. Fund it inside 5 years, and you've likely created a penalty. This is a planning ahead tool, not a last-minute fix. Traditional life estate deeds deserve a warning label. They create a present gift of the remainder interest to your beneficiaries, and you keep a life estate. That often triggers the lookback if done inside 5 years. You also lose control. You typically can't sell or refinance without the remainderman's consent, and a sale can split proceeds in a way that hurts eligibility. In states that allow ladybird deeds, the enhanced life estate is usually the better option because you keep control and avoid a completed gift during life. If your state doesn't allow ladybird deeds, consider a TOD, or if you have time, an MAPT. A few cross-cutting landmines. First, state availability and definitions. Ladybird deed is not a universal term. Some states don't recognize enhanced life estates. Others have quirks about how powers must be reserved to the owner. If the deed isn't drafted to your state's requirements, you might accidentally create a traditional life estate and trigger the lookback. Second, title company policies. Even in ladybird states, some title underwriters scrutinize these deeds when beneficiaries sell. Use an attorney who knows local recording and underwriting practices. Third, beneficiary coordination. Probate avoidance only works if the chain is clean. If your named beneficiary dies before you and you didn't name alternates, the property can bounce back into your probate estate. In a probate-only recovery state, that mistake reopens the MERP door. Build contingencies. Fourth, capacity and timing. Deeds require legal capacity. If you wait until crisis, the elder may not be able to execute valid documents, forcing guardianship or probate, workarounds that put the house back on the table. Let's stack the tools by scenario. If you're 5+ years out and want global protection, a MAPT is strongest. If you're inside 5 years but still have capacity and you're in a Lady Bird state, the Enhanced Life Estate Deed is the cleanest way to shield the home at death while preserving eligibility. If your state uses TODs and not Lady Bird, a TOD can accomplish the probate avoidance goal, but won't give you the same retained powers flexibility as a Lady Bird in some jurisdictions. If someone suggests a traditional life estate deed as a quick fix inside 5 years, ask hard questions. You might be creating a penalty and giving up control you'll regret. One more practical edge: pair your real estate tool with beneficiary designations on everything else. Payable on death for bank accounts, transfer on death for non-qualified brokerage, and named beneficiaries on life insurance and retirement accounts. These don't solve eligibility by themselves, but they keep assets out of probate, which reduces recovery targets, and keep meticulous records to negotiate any claim that survives. Home maintenance, funeral costs, and verified caregiving that delayed institutionalization. The goal is simple: right tool, right time, right state. Use what your state recognizes, respect the lookback, and keep the home off the probate conveyor belt. The 9 classic mistakes that trigger recovery anyway. Mistake 1: thinking the home is exempt, so it's safe. Eligibility and recovery use different rule books. The home can be exempt for getting approved, then become the first target after death if it passes through probate. If you don't change the title path, you didn't protect the house. You just delayed the problem. Mistake 2: using the wrong deed. A traditional life estate deed gives your kids a present remainder interest. That's a gift during life, which can trigger a penalty inside the 5-year lookback, and you lose control to sell or refinance without their consent. In states that allow it, the Enhanced Life Estate, Lady Bird deed, keeps full control and typically avoids the lookback because the transfer completes at death. Use the wrong deed, and you create penalties and headaches. Mistake 3: waiting for later. Families intend to fix title after mom settles in. Then capacity slips, someone gets hospitalized, or the year runs out. Deeds require legal capacity. If you miss that window, you might need guardianship or die with a standard deed, sending the home into probate, exactly where estate recovery lives. Mistake 4: confusing joint ownership with beneficiary designations. Adding a child as a joint owner today often gives them present rights. That's a gift that can trigger the lookback and expose the house to your child's creditors, divorces, or lawsuits. A transfer on death deed or Lady Bird deed doesn't give present ownership, avoids probate at death, and sidesteps those risks in many states. Right mechanism, right timing. Mistake 5: selling the house after recording a Lady Bird deed and parking the cash. The deed protects title at death. It doesn't protect sale proceeds during life. Cash in your account is countable for eligibility. If a sale is likely, talk with counsel about timing, trust structures, or whether a MAPT established well before care can hold proceeds safely. Don't turn a protected home into unprotected cash by accident. Mistake 6: relying solely on spouse or disabled child exemptions. Those protections are deferrals, not permanent shields. When the spouse dies or the minor turns 21, the state can come back. The smart move during the deferral is to reroute title out of probate, Lady Bird deed, where recognized TOD where available, or a properly funded trust if time allows. Use the deferral as a planning runway. Mistake 7: DIY documents that don't meet state quirks. Lady Bird deeds and TODs are state-specific. If your deed misses mandatory language, lacks proper reservations of power, or isn't recorded correctly, you might have created a traditional life estate or nothing at all that can trigger the lookback or dump the property into probate. Local elder law attorneys know the wording and the title underwriter's expectations. Templates don't. Mistake 8, missing hardship deadlines and documentation. Undue hardship waivers exist, but they're not automatic. States like Texas give heirs about 60 days from the intent to recover notice to apply. You'll need income proof, valuations, and evidence if the property is a primary income source. If you show up on day 61 with no paperwork, you're done. Treat hardship like an emergency filing with a checklist and calendar reminders. Mistake 9, ignoring small non-real estate assets that reopen probate. You might nail the deed, but leave a bank account or vehicle titled only in the decedent's name. If that asset forces a probate proceeding, the door opens for the state's claim. Clean the chain. Payable on death designations on bank accounts, transfer on death for brokerage, and vehicles where allowed, and updated beneficiaries on life insurance and retirement accounts. One stray account can undo careful home planning. Here's the shortcut that ties all of this together. Ask one question for every asset. Will this pass through probate? If the answer is yes, or I'm not sure, fix it. For the home in a probate-only state, that likely means a Lady Bird deed or TOD. For accounts, POD or TOD. For complex estates and early planners, a Medicaid Asset Protection Trust, funded outside the 5-year lookback, can lock down multiple asset types and keep proceeds protected if you sell, and keep records that reduce any claim that survives. Home maintenance, funeral costs, and documented caregiving that delayed institutionalization. Avoid these 9 mistakes. And you're not gaming the system. You're aligning with the rules. Mandatory recovery targets probate assets tied to long-term care costs after 55. So you move the house and the rest of the estate off that track legally and on time. What Medicaid can actually recover? The math. Let's turn policy into numbers because this is where decisions get clear. Medicaid can only recover what it actually paid for covered long-term services and supports after age 55, plus related hospital and prescription drug costs tied to that care. Not a dollar more. And recovery is limited to assets that are legally reachable, most often assets that pass through probate in states like Texas. So the ceiling is the lesser of 2 amounts: the state's paid claims or the net value of estate assets it can reach. Start with a simple ledger. Suppose Medicaid paid $168,000 for 2 years of nursing facility care, home health, and related prescriptions. The estate has a homestead worth $250,000, a car worth $6,000, and a checking account with $4,000. If the house and the car pass through probate, and there's no mortgage, the gross estate available is $260,000. But claims don't reduce gross value. Expenses do. Probate pays in an order: administrative costs, funeral expenses, certain priority claims, then general creditors, where Medicaid sits in many states. You deduct what's allowed before paying Medicaid. What can you subtract? Reasonable and necessary costs to preserve the estate: property insurance, taxes, utilities to keep pipes from bursting, yard maintenance to prevent code fines, and repairs to maintain market value. Funeral and burial costs reduce the pot. Documented personal funds spent on caregiving that delayed institutionalization can sometimes offset the claim, depending on your state's policies. In Texas, MERP guidance allows deductions for estate administration, necessary maintenance, and some verification-based care expenses. Keep receipts. If you can't prove it, it usually doesn't count. Now, watch how this math plays out. From the $260,000 gross, subtract $12,000 in funeral and burial, $8,000 in realtor commissions and closing costs, $3,500 in insurance, taxes, and utilities, and $2,500 in verified repairs. You've reduced the estate to $234,000. Medicaid's claim is $168,000. The recoverable amount is the lesser of $168,000 or $234,000, so $168,000. Heirs would see the remainder, about $66,000, assuming no other creditors. If the state had paid $300,000 instead, recovery would still cap at $234,000 because you can't pay more than what's in the estate after valid deductions. Cost-effectiveness rules can block tiny recoveries. States must avoid spending more to recover than they'll collect. Some set thresholds or list situations when recovery isn't pursued, e.g., very small estates or minimal Medicaid paid amounts. Don't bank on it for a house with real equity, but it can save low-value, high-cost-to-sell situations. Hardship waivers change the math by reducing or eliminating the claim, not by altering what Medicaid paid. In Texas, heirs have about 60 days from the notice to apply. Grounds include pushing heirs below poverty, modest homestead value relative to family income, or the property being a primary income source like a family farm. If approved, the claim is waived or reduced according to the hardship criteria. Without a timely, well-documented application, the default math returns. Here's a key nuance. If the home never enters probate via a Lady Bird deed in Texas or a valid transfer on death deed, then it's outside the estate that MERP targets in a probate-only system. In that case, the math on the house is simply zero because it's not part of the recoverable pool. Medicaid can't recover against what it can't reach. That's why routing around probate isn't just legal theory, it changes the arithmetic. Two more quick examples. If there's a mortgage, recovery comes after liens. House sells for $250,000, mortgage is $90,000, closing costs $15,000, net $145,000. Medicaid's paid claims are $120,000. Recoverable amount becomes $120,000. Heirs see $25,000. If multiple heirs invested $10,000 each into documented home preservation, those amounts can reduce the net further before the claim applies. So the playbook is simple. Lower the recoverable pool with legitimate documented expenses. Use hardship when you qualify. And best of all, keep the home off the recoverable balance sheet by avoiding probate in a probate-only state. The numbers will do the rest. Pre-crisis plan, 12 to 36 months before care. This is the window where small moves do the heavy lifting. You're close enough to care that you can see it coming, but not so close that every transfer risks a penalty. The goal here is twofold. Line up probate avoidance on the home without triggering the lookback, and prep documentation that either shrinks a future claim or qualifies you for hardship if you need it. Start with the deed. If your state recognizes an enhanced life estate deed, Lady Bird deed, meet with an elder law attorney and get it drafted correctly. The reason this works in states like Texas is simple. The transfer doesn't complete until death, so it typically doesn't trigger the 5-year lookback, and the property passes outside probate. That keeps the house off the MERP conveyor belt in probate-only states. Make sure the deed reserves full powers. Sell, mortgage, lease, and change beneficiaries. Record it properly. Add primary and alternate beneficiaries, so one death doesn't bounce the property back into probate. If your state uses transfer on death deeds for real estate, a TOD can achieve the same probate avoidance goal. Confirm your state's statute, exact recording requirements, and whether alternates are allowed. A missed recording or a predeceased beneficiary can accidentally reopen probate, so build redundancy into the form. Either way, you're answering the only question that matters for recovery. Will this house hit probate? Your plan makes the answer. No. Next, sweep the rest of your estate for probate traps. Add payable on death beneficiaries to bank accounts. Add transfer on death instructions to brokerage, and, where allowed, vehicles. Update life insurance and retirement account beneficiaries. None of this solves eligibility, but it stops one stray account from forcing probate and inviting a claim. Keep beneficiary lists coordinated and current. Now, the trust conversation. A Medicaid Asset Protection Trust is powerful, but triggers the look back when you fund it. In this 12 to 36 month period, you're inside 5 years. That means a MAPT will likely create a penalty if you apply before the clock runs. So be selective. If you're confident you won't need Medicaid for 5+ years, you can still start a MAPT now and run the clock. If care might be sooner, press pause on funding new assets into a MAPT and lean on deeds and beneficiary designations that don't create present gifts. You can still set up the trust infrastructure, so it's ready if the timeline stretches. Create your documentation engine. Start a dedicated folder, digital and physical. Keep receipts for home insurance, taxes, utilities, repairs, and maintenance that preserve value. If a family member is providing care that keeps you out of a facility, formalize a caregiver agreement at fair market rates, log hours, and pay by check. If your state later allows deductions for verified care that delayed institutionalization, you'll have a clean record. This is how you legally shrink a future claim. Assess title company realities. In Lady Bird and Todd states, some underwriters have preferences about deed language and affidavits at sale. Your elder law attorney will know the local practice. That matters because your beneficiaries may sell later. You don't want avoidable delays that pressure them into bad deals. Stress test capacity and decision-making. Deeds and beneficiary changes require legal capacity. If capacity is slipping, move faster. Consider updated powers of attorney tailored for Medicaid planning, including authority for beneficiary changes, TODs, and dealing with MERP claims. A strong POA can prevent a guardianship if crisis hits. If you own a business, farm, or rental that sits on the homestead, get advice now. Hardship waivers often consider whether property is the primary income source for heirs. That doesn't mean you rely on hardship, but you structure records, leases, tax returns, evidence of operations, so the file is ready if needed. In Texas, heirs have roughly 60 days after a recovery notice to apply. A complete pre-built packet beats scrambling. Think through sale risk. If downsizing is likely, a Lady Bird deed won't protect sale proceeds during life. That cash becomes countable. Map scenarios with counsel. Timing of any sale, whether a pre-existing MAPT could hold proceeds if you're outside Lookback, or whether delaying a sale is smarter. Don't convert protected equity into unprotected cash by accident. Coordinate family expectations. Explain that the deed or TOD doesn't give them ownership today. That means their creditors can't touch the house now, and there's no gift for look-back purposes. It also means they have no right to force a sale. Clear expectations avoid pressure that leads to bad transfers. Finally, create your MERP playbook, a one-page checklist. Contact info for your elder law attorney, where the recorded deed is beneficiary lists, account numbers with POD/TOD, the location of your documentation folder, and a simple instruction: do not open probate for the house. Add a calendar reminder to review beneficiaries every 6 months. This turns a complex process into a repeatable routine. If you execute just these moves in the next 30 to 90 days, you'll have aligned eligibility, recovery, and title. You haven't gamed anything. You've used your state's rules as written, and you've traded panic later for quiet preparation now. Crisis plan, in care or within Lookback. If you're already in care or inside the 5-year Lookback, the game is containment and clean execution. You can't undo time, but you can stop making it worse and still protect the house from recovery in probate-only states. Start with a freeze on gifting. No new transfers for less than fair market value. That includes helping kids with cash, adding children to deeds or accounts, and $1 sales. Every gift inside the Lookback stacks a penalty that starts exactly when you can least afford it, when you're otherwise eligible and the facility wants payment. Pause document and route everything through fair value exchanges. Next, separate eligibility from recovery. You may need to fix eligibility now while designing a probate avoidance path for later. In a state like Texas, that often means two parallel tracks: cure or mitigate lookback issues to get approved, and get the deed right so the home won't hit probate at death. Those can happen at the same time. Triage the lookback. Pull 60 months of statements. Flag any transfer that looks like a gift. Large cash withdrawals, checks to family, title changes that conveyed present ownership, trust funding inside the window. Build a simple ledger: date, amount, recipient, purpose, and supporting documents. The goal is clarity. Either prove a fair value exchange or plan a cure. Cures come in a few flavors. If funds are still available, return the gift. Medicaid treats a full or partial return as curing that portion of the penalty. If funds are gone, you can offset with documented fair value services, legitimate caregiver agreements, home repairs, or maintenance that preserved value. But you need contracts, time logs, invoices, and proof of payment. Without paper, Medicaid presumes a gift. If a penalty is unavoidable, plan the bridge. Calculate the penalty months by dividing the total uncompensated transfers by your state's average monthly nursing home cost. Then create a payment plan for that period using available assets or family help. Avoid new gifts while paying the bill. Meanwhile, finalize probate avoidance moves for the home so that when death occurs, the property doesn't invite a recovery claim. For the house, capacity decides your options. If the owner still has legal capacity and your state recognizes an enhanced life estate deed, a ladybird deed is usually the fastest way to route around probate without triggering the lookback. Record it correctly, reserve all powers, and name alternates. If your state uses transfer on death deeds, prepare and record a TOD with backups. If capacity is gone, explore whether an existing power of attorney authorizes deed changes or TODs. If not, you may need a guardianship and court approval, which can be slower and risk missing the window. Move fast on capacity assessments. Do not sell the homestead casually during crisis. A sale converts protected equity into countable cash. If a sale is necessary, map the timing with your attorney. If a pre-existing Medicaid Asset Protection Trust was funded more than 5 years ago, proceeds can stay protected inside the trust. If no MAPT exists or it was funded inside the window, selling now can blow up eligibility. Sometimes the better move is to hold, preserve, and prepare the deed for clean transfer at death. Tighten up the rest of the estate. Add payable on death beneficiaries to bank accounts and transfer on death to brokerage, and, where allowed, vehicles. Update life insurance and retirement beneficiaries. One stray account forcing probate can open the door to a recovery claim even if the house is routed correctly. Make a list, assign a beneficiary, and verify with the institution that it's on file. Set up your deduction file now. Keep receipts for insurance, taxes, utilities, urgent repairs, lawn and pool care if needed to preserve value, and any legitimate costs that maintain the property. If family is providing care that delays institutionalization, formalize a caregiver agreement at fair market rates and log hours. In Texas, MERP guidance allows deductions for necessary maintenance and certain verified costs. The state doesn't accept estimates, only proof. Prepare for hardship as a backstop, not a plan. When a notice of intent to recover arrives, the clock is short. Texas gives heirs about 60 days to apply. Start building the packet. Heir income and household size, property valuation, proof if the property is a primary income source, and any facts that meet your state's criteria. Even if you hope to, avoid probate. Having hardship materials ready is cheap insurance. Coordinate with the facility and state caseworker. If you're curing a penalty, tell the facility your timeline and show the math. If you've returned funds, get receipts and proof of deposit. If you're asserting that a transfer was for fair value, submit contracts and logs. Clear communication reduces denials and delays. Finally, write your crisis checklist for the family. Do not gift. No joint owners added. Confirm recorded deed or TOD. Add POD/TOD on accounts. Store the documentation folder. And call the elder law attorney before opening probate. In crisis, simple checklists prevent expensive mistakes. You can't erase the look back, but you can box it in. Cure what you can, bridge what you can't, and reroute the home away from probate. That combination gets you through eligibility today and blocks recovery tomorrow. Paperwork, process, and timeline management. Let's make this simple and executable. You've got 3 phases to manage: before death, immediately after death, and during any claim or probate. Each phase has specific paperwork, deadlines, and one person in charge so nothing slips. Before death, build your MERP file. One folder, digital and physical. In it, keep the recorded deed or transfer on death deed, powers of attorney, beneficiary lists for every account, the latest property tax bill, homeowners insurance declarations, utility statements, and a maintenance log. Add receipts for repairs, lawn care, pest control, anything that preserves value. If a family caregiver is helping, include a written caregiver agreement, time logs, and proof of payment at fair market rates. This documentation can reduce a future claim, but only if it's organized and verifiable. Create a 1-page estate map. List every asset, how it passes POD, TOD deed trust, and who the beneficiaries are, plus alternates. Include account numbers and the institution's contact phone. Put do not open probate for the house. In bold if you've routed it with a Lady Bird deed or TOD. Add your elder law attorney's contact info. Tape a copy inside a clearly labeled binder and share a PDF with the trusted agent named in the power of attorney. Assign roles now. 1. Documents captain monitors mail, records deeds, and keeps the file current. 1. Property captain handles insurance, taxes, and upkeep. 1. Beneficiary captain confirms POD/TOD status with banks and brokerages annually. Calendar a 15-minute review every 6 months to confirm beneficiaries renew insurance and check that the deed is recorded and legible in county records. Immediately after death, switch to a 72-hour checklist. Secure the property. Keep utilities on to prevent damage. Update insurance from homeowner to estate or vacant home coverage if required. Carriers deny claims if status is wrong. Take dated photos of condition. Notify the elder law attorney before anyone opens probate. If the house bypasses probate by deed, you want to avoid filing anything that drags it back in. Watch the mail. States send a notice of intent to recover to the personal representative or last known address. In Texas, heirs generally have about 60 days from that notice to request an undue hardship waiver. The clock starts on the notice date, not when you finally open the envelope. Put a sticky note on the binder. Hardship window, 60 days. If hardship might apply, start the packet the same day. Income verification for heirs, property valuation, proof if the property is a primary income source, and any documents the state's criteria require. If probate is necessary for other assets, prepare cleanly. File an inventory listing assets and known creditors, including the state's potential claim. Keep estate administration expenses documented. Letters, testamentary fees, attorney fees, court costs. Track ongoing property expenses with receipts and a ledger. These are the deductions you'll use against any MERP claim. The more precise the records, the smoother the negotiation. Submit claims and responses in writing. If you're applying for hardship, use the state's form, attach exhibits, and get delivery confirmation. If you're disputing amounts, request an itemized accounting of Medicaid paid services by date and type. Compare it to your records. Errors happen. Ask for written acknowledgement of receipt for everything you send. Create a simple index so anyone can follow the paper trail. Set a timeline. Week 1, secure property, insurance, photos, attorney call, mail watch. Week 2, verify recorded deed or TOD and beneficiaries on all accounts. Order death certificates. Start hardship packet if applicable. Weeks 3 to 4, compile estate expenses and maintenance receipts. Request itemized Medicaid accounting. Prepare any necessary probate filings for non-deeded assets. Weeks 5 to 8, submit hardship or negotiation package. Respond to information requests within 5 business days. Line up realtor only if a sale is consistent with your plan and won't jeopardize eligibility or recovery defenses. Use checklists religiously. Title clarity, beneficiaries confirmed, utilities stable, insurance correct, mail monitored, deadlines calendared, submissions tracked. If you remember nothing else, paperwork wins. Organized records, quick response times, and clean titles are how families keep the home off the recovery conveyor belt and shrink any remaining claim to the legal minimum. The one form families skip that hands over the house. There's one piece of paper that decides whether your house quietly moves to your kids or rolls straight into probate with a bill attached. It's not a will. It's the deed choice that routes the house, either a ladybird deed in states that allow it or a transfer on death deed, where that's the tool. Families nail the Medicaid application and forget the form that actually routes the property. Then probate opens, and the state's recovery claim walks right in. Why this one form matters. In probate-only recovery states like Texas, Medicaid can't touch what doesn't pass through probate, a properly executed ladybird deed. Or TOD means the home transfers at death by operation of law outside probate. No probate, no MERP lane. Skip the deed, and your exempt home becomes the estate's biggest asset and the prime target. Now, what does properly executed mean? 3 things. First, the right tool for your state. If your state recognizes enhanced life estates, the ladybird deed usually beats a traditional life estate because it reserves powers to sell, mortgage, and change beneficiaries without consent. If your state uses TODs, use the statutory form. Don't mix terms. A ladybird label in a non-ladybird state can backfire. Second, correct language and recording. The deed needs the reserved powers spelled out, accurate legal description, correct grantee names, and it must be signed, notarized, and recorded in the county where the property sits. For TODs, recording before death is usually mandatory. If it isn't recorded, it often doesn't exist for transfer purposes. No recording, no bypass. Third, name alternates. If a beneficiary dies before you and there's no alternate, many deeds fail back into your probate estate. That single miss reopens MERP's door. List primary and contingent beneficiaries and review them yearly. Let's make this practical. If you're in Texas and capacity is intact, call an elder law attorney and say, I need an enhanced life estate deed with reserved powers and contingent beneficiaries. Ask them to confirm the county recording requirements and whether local title underwriters have preferred language. Get a certified copy back and place it in your MERP folder. If your state uses TODs, ask for the statutory TOD with alternates and record it now. Common ways families blow this. They rely on the will. Wills direct probate. That's the wrong river. Or they add a child as a joint owner just to be safe. That can be a present gift triggering the lookback, and it exposes the house to the child's creditors. Or they download a generic deed template that doesn't reserve powers correctly, accidentally creating a traditional life estate with a completed gift that can trigger penalties and strip control. Another quiet failure, not syncing house beneficiaries with accounts. You route the house outside probate, but leave one checking account in the decedent's name with no payable on death designation. That tiny account forces probate. Once probate opens, the state's claim joins the party. Clean the chain. POD on bank accounts, TOD on brokerage, beneficiaries on life insurance and retirement accounts, and the deed for the house. If capacity's slipping, move. Deeds require legal capacity. If it's gone, you'll need authority and the power of attorney to execute a ladybird deed, or TOD. Many boilerplate POAs don't include that power. If the POA is weak, you may be stuck with guardianship and traditional probate, which invites recovery. Review the POA language today. Here's your 2-sentence checklist. 1. Do we have a recorded ladybird deed or TOD on the homestead with alternates? 2. Are all non-home assets set to transfer by beneficiary, POD, or TOD, so nothing forces probate? If either answer is no, fix it this week. That single form is the difference between a quiet transfer and an avoidable bill. State variations. How to get it right where you live. Everything we've covered works if you match it to your state's rules. Medicaid Estate Recovery is federally required, but states write the playbook on how they chase assets, what counts as the estate, and which tools they recognize. Your plan has to be local. Start with one question. Is your state probate only for recovery, or does it use an expanded estate definition? In probate-only states, Texas is the classic example. Recovery targets assets that pass through probate. Route the home outside probate, and you've usually shut the door. In expanded estate states, the state may reach certain non-probate transfers, life estates, or living trusts. That doesn't mean you have no options, but it does change which tools carry the most weight. Next, confirm which deed tools your state actually recognizes. Ladybird deeds, enhanced life estates, are only available in a minority of states like Texas and Florida, if your state allows them. They're powerful for late-stage planning because the transfer completes at death and typically doesn't trigger the 5-year lookback. If your state doesn't allow them, look for a transfer on death deed statute. Many states now permit TODs for real property, but the rules vary. Some require strict recording before death, some need exact statutory language, and some need alternates named to prevent failure. If your state has neither ladybird nor TOD, you'll lean more on trusts and beneficiary designations. Now look at hardship waivers and thresholds. Federal rules require states to offer hardship, but criteria and deadlines differ. Texas gives heirs about 60 days to apply after the intent to recover notice. Other states may have shorter or longer windows, different income tests, or special provisions for income-producing property like family farms. Some states set cost-effectiveness thresholds. If the estate is too small, they won't pursue. The ranges differ widely. Know the window, the criteria, and the documentation your state expects. Then check the scope of recoverable services. Federal minimums include nursing facility care, home and community-based services, and related hospital and prescription drugs for people 55 and older. Many states expand recovery to more services or younger, permanently institutionalized individuals. If your state goes beyond the minimum, expect broader claims. If it sticks to the minimum, you're dealing with a narrower ledger, but the asset path still matters more than the dollar amount. Don't forget lookback interpretations. The 5-year lookback is federal, but states differ on what they treat as a gift. Adding a joint owner might be a present transfer in one state and a non-event in another, depending on survivorship and immediate access. A traditional life estate is usually treated as a present gift. An enhanced life estate often isn't, where recognized. With accounts, a transfer on death beneficiary generally isn't a gift, but adding a non-contributing joint owner can be. This is where local counsel pays for itself. Here's a quick map for decisions. If you're in a probate-only state with ladybird deeds, use the ladybird deed for the home, POD/TOD for accounts, and clean beneficiary designations. If you're in a probate-only state without Ladybird, but with TODs, use the TOD with alternates and the same beneficiary sweep. If you're in an expanded estate state, consider a Medicaid Asset Protection Trust if you're 5+ years out, and have an attorney confirm whether your state reaches TODs or enhanced life estates for recovery. If it does, the trust may be the safer path once the lookback clears. 2 local landmines to ask about. 1. Title underwriting norms. Even when a deed is valid, local underwriters may require specific affidavits or statutory references. Your elder law attorney will know the language that avoids closing headaches. 2. State-specific exemptions. Some states have a caretaker child transfer exception or allow deductions for verified family caregiving that delayed placement. Others interpret narrowly. If your state honors it, build the paper trail now. Physician statements, care logs, and proof the care kept the person at home for the required period. Your action step is simple. Google your state Medicaid Estate Recovery Manual and read the sections on scope, hardship, and definitions of estate. Then call a certified elder law attorney and ask 3 questions. Does our state recover only from probate assets or an expanded estate? Which deed tools are recognized and preferred by local title companies? And what are the hardship criteria and deadlines? Once you have those answers, plug the right tool into the same framework you've learned. Bypass probate where it counts, respect the look back, and document everything. That's how you make the national rules work on your street. Quick start checklist and next steps. Let's turn this into action. You can finish this week. Here's your quick start checklist in order. Step 1. Identify your state rules. Write down probate-only or expanded estate, which deed tools are recognized, Ladybird deed, transfer on death deed, or neither, and the hardship window and criteria. If you're in Texas, note, probate-only recovery, Ladybird deeds recognized, hardship window about 60 days from the notice. Step 2, lock the home's path. If your state recognizes an enhanced life estate, Ladybird deed, book an elder law attorney and say you need a Ladybird deed with full reserve powers and contingent beneficiaries recorded now. If your state uses TODs, get the statutory TOD with alternates and record it. Verify recording with the county site. Step 3, clean the rest of the estate. Add payable on death beneficiaries to bank accounts and transfer on death to brokerage and, where allowed, vehicles. Update life insurance and retirement beneficiaries. The goal: nothing forces probate. Step 4, build your MERP folder. Include recorded deed/TOD, beneficiary lists, powers of attorney, last property tax bill, insurance declarations, utility statements, a maintenance log, receipts for repairs, and any caregiver agreement with time logs and proof of payment. Add a bright note: do not open probate for the house. Step 5, time-proof the plan. Add primary and alternate beneficiaries on the deed and all accounts. Calendar a semi-annual 15-minute review to confirm beneficiaries, insurance tax status, and deed recording remains visible in county records. Step 6, decide your timeline strategy. If you're 5+ years from likely care, discuss a Medicaid Asset Protection Trust for non-retirement assets, and maybe the home. If you're inside 5 years, avoid funding a new MAPT. Rely on deeds and beneficiary designations that don't create present gifts. Step 7, shore up documentation to shrink any claim. Keep receipts for insurance, taxes, utilities, lawn, pest control, and repairs. If caregiving keeps someone out of a facility, formalize a caregiver agreement at fair market rates and log hours. These records can reduce recovery or support hardship. Step 8, capacity check. If capacity is slipping, prioritize deed execution and beneficiary updates now. Review your power of attorney to confirm it authorizes real estate beneficiary deeds, or TODs. Strengthen it if needed. Step 9, sale risk planning. If downsizing is likely Do not sell casually. A sale converts protected equity into countable cash. Map timing with your attorney. If a pre-existing seasoned MAPT exists, proceeds can stay protected. If not, consider holding and letting the deed transfer at death. Step 10. Family briefing. Explain that the deed, or TOD/TA, does not give ownership today. No creditor exposure, no look-back gift, and no right to force a sale. Align expectations to avoid accidental transfers. Step 11. Create the crisis card. 1 page. Attorney contact, location of the MERP folder, instruction not to open probate for the homestead, hardship reminder window, and a checklist to add POD/TOD to any new accounts. Step 12. Pre-draft hardship. If hardship might apply in your state, assemble a template packet. Air income/household, property valuation, proof of income producing use, and relevant state criteria. When the notice arrives, your days from filing, not months. Do these steps in order. If you hit a snag, prioritize steps that block probate for the house and lock beneficiary designations. Those 2 moves neutralize most recovery in probate-only states while your documentation trims whatever's left. If you remember one thing, it's this: eligibility rules and recovery rules are different. Protect the house by keeping it out of probate and respect the 5-year look-back. Want the templates, checklists, and state-by-state tool map? Grab the free toolkit linked below. Then watch the advanced walkthrough on maps next. Subscribe for the state variations deep dive. Share this with the person handling mom or dad's paperwork before the letter arrives.